We know who wants the Fed to cut. That's the president. Which brings us to the Lisa Cook story. There is a court hearing going on right now over President Trump's attempted firing of Fed Governor Cook. It just ended. Eamon Javers is live outside the courthouse in Washington with the very latest. What do we need to know, Eamon?
Scott, what you need to know here is that hearing is now over, and it's ended with no decision from the judge here on whether or not to issue a preliminary injunction. The judge says she wants to see more filings from both sides here on Tuesday. So we go into the Labor Day weekend with no decision from the judge on the status of Lisa Cook and the status of this lawsuit. And what we heard in the second half of this hearing, Scott, was a lengthy back and forth between the judge and between the Department of Justice's attorney who's arguing the case here, Yaakov Roth. Roth arguing on behalf of the president here. And the central issue was this issue of what does for cause mean? What authority does the president have to fire somebody from the Fed board or not? And what is the definition of that term? Roth gave a definition in court about that term. He said, cause is more than a policy disagreement that bears on the official's ability to do the job. And then he added, and you could add, that's an issue of whether the question was known at the time. So that is, was there an issue that came up that was adjudicated by the Senate when the official was confirmed? If that's the case, Roth suggests, well, then that's not sufficient for cause for the president now to go back in time and say, well, they didn't adjudicate it enough or what have you. What was interesting about that argument is that Abby Lowell, who is the attorney for Lisa Cook, jumped on that at the end of the hearing and said, well, wait a second. If the government is arguing that if it had to not have been known at the time in order to be acceptable for cause, we can go back and pull Lisa Cook's filings, her mortgage documents, banking records, all of those would have been sent to the Senate committee that confirmed her at the time, and therefore you could say it was known at the time. And so therefore this point is moot. That was an interesting back and forth between the two sides, and that may have some bearing on where we go here. Another interesting question here was whether or not Cook got appropriate notice. And the judge says here, I had a strong reaction to the idea that there was notice provided because of the president's tweet. She says to the Department of Justice, you're not saying that what happened here satisfies due process, are you? And the DOJ says, yes, notice was given. The judge responds by that social media post, and the Department of Justice says, yes. So what the Department of Justice is arguing here is that the president's social media posts are sufficient notice to terminate Lisa Cook from the Fed. So the judge is going to have to consider all that. She said it's a novel case. She's going to go do some thinking about it, and we don't know now whether there's going to be a preliminary injunction in this case or not, Scott.
Wow, it's a lot to grasp. Eamon, thank you very much. Outside the courthouse, you'll keep us up to date.